with UCP. I love this organization. It's family, and I'm just proud to see everything that Doug and his team and Megan do all the time. It's such a great group of people who really do care about the population that we serve. You already heard my background. One of the unique things about my practice is that more than half of our clients have loved ones with disabilities. And that's kind of unusual, but I fell into special needs planning. I don't have a great story about a brother or a sister or somebody that I could tell you. I just fell into it, and it turns out to be one of the best things that ever happened. Estate planning is fundamentally about peace of mind, right? That's people say, what do I get out of doing this work? And the answer is you get peace of mind, a meaningful peace of mind. You're doing something that really matters. When I practice in this area, what matters a lot to families, and so it's a joy to be able to do that. Little disclaimer: I am a lawyer, so lawyers have to have disclaimers. I do want to say that if you're watching this on a recording someday in the future, the things that we talk about today are subject to change. So just know that you might want to talk to somebody about your current circumstances. What we're going to talk about today is accurate as of today, but this is an evolving area. So do want you to be aware of that. The things that I want to cover this morning are a lot, and the slides are packed with information. I am not going to read every slide to you guys. The reason I do it is so that you have the information in writing and you can refer to it later. And so that's why there's so much there. But we're going to try and get through all of these topics. Unfortunately, I'm starting with the one that is the least interesting, and that's public benefits, and just understanding some of the rules, or maybe refreshing your mind as to some of the rules that apply when public benefits are at an issue. We're going to talk about making decisions about the future, which is why we're here. We're going to talk about what makes an effective plan using special needs trust. I'm going to touch on ABLE accounts and conservatorships as well, because they're a part of what we do. I'm going to give you some suggestions for choosing legal advisors. And then I hope to inspire everybody by reminding us all of the consequences of procrastination. The interesting thing is that everyone in this room has already overcome that obstacle in many ways, right? You're here to kind of deal with this. Nobody really likes to talk about death or disability, but you've overcome whatever kept you away from this, and you're here to learn today. So that's a really good sign. But there are a lot of our friends and family who are putting this off. More than half of the public never does any planning for their estate. And so maybe something you learned today will be useful to a friend or a family member as well, and you can share it with them. And then we will have a Q&A time at the end. So let's start with public benefits. There are two main categories of public benefits that we're concerned about. There's the financial side of it, and then there's the medical side of it. And the financial side and the medical side, they link together. So they're integrated together. And in each category, financial and medical, we have two subcategories. So in one sense, we always have those benefits that a person is entitled to because they or someone else paid into the system. And as a result of a work record, they have some benefits to them so that they're entitled to. So on the right here on the screen, we have Social Security and Social Security disability insurance. And those come to us when we draw a paycheck. They can also come to our loved one in certain circumstances if they have disabilities because we drew a paycheck. But there's also a whole nother category of benefits, SSI, supplemental security income, that you can qualify for under certain circumstances. And essentially what you need to know up front is that they're means tested, which means you can't have too many assets, you can't have too much income, or you won't qualify for SSI. You might, if you have a disability, like if I can't work anymore and I go out on disability, I'm going to get that. That payment. And even if I were to inherit a bunch of money from my Uncle Bob, then I'm still going to get that. But if I'm relying on SSI and Uncle Bob just leaves me a bunch of money directly, I'm going to lose it because I'm going to be over the limit. So we're going to talk about all of that. But you're going to see that's the general overview on the financial side. And it turns out the medical side is really similar. On the right, we have those things that you're entitled to, or someone in your family might be entitled to because of a work history. And so that's going to be typically Medicare. And Medicare often comes to families if someone has SSDI, if they have that insurance that pays out because they paid into the system. If they get SSDI for long enough, you can also automatically qualify for Medicare. And Medicare is going to cover a lot of the medical needs that we have. But there's also the needs-based program, and that's Medi-Cal. And so that's on the left. And Medi-Cal has different rules. You know, a couple of years ago, you could be a billionaire and get Medi-Cal in California. And then we kind of realized that well, you can do the math. Our friends down the street at the Capitol building did the math and realized that that's probably not sustainable. So things changed, right? And now we have a $130,000 cap for Medi-Cal. But for reasons that we're going to get to, really the cap is $2,000. We'll get to that. So let's go deeper. Let's talk about SSI. This is a really important program. It provides income for food and shelter. It used to be food, shelter, and clothing, but it's considered income for food and shelter. And right now in California, it generally pays about $1,233.94 a month if somebody with disabilities is living independently. Or they could be in your house and paying their way, and they'll get that amount of money. It is a gateway to Medi-Cal. It turns out if you have $1 of SSI that you receive Medi-Cal automatically. So SSI leads to Medi-Cal. I'll reinforce that a couple times. But for many people, that is how they end up with their medical coverage, is because they have SSI. To qualify for SSI, a person has to be federally disabled. And that does not mean they have a placard, they're eligible for a placard in their car, and they can park preferentially. That's not enough. What it means, we'll get to in a minute, but federal disability is different than what we might in our heads think of as disability. But you got to be federally disabled. And then, like I said, you've got to have limited assets and income. It's needs-based. If it started early, let's say somebody is 22 years old and they qualify for SSI, and that money comes in, and it might be necessary for their food and shelter, but some families may have that covered already. And so what happens is that money comes in, and it can be paid to mom or dad or caregiver in the form of rent or a portion of household income for food. Let's say that money comes into the family, and mom or dad or caregiver can save that money, invest it, and then return it later on to the individual. Friends of mine have done the math, and you can actually, although it's $1,233, really that's going to provide food and shelter for somebody in California. But the thing is, once it's invested, it can turn out to be at least $1 million, maybe even $2 million over the course of a person's lifetime. So it's not something to just disregard. I always encourage people to apply for it. Disability, let's define that. It's essentially an inability to work, an inability to engage in substantial gainful activity as a result of a medically determinable condition that is expected or has lasted for at least 12 months and result in death, not and result in death. And so that's what it means to be federally disabled. It's all tied into whether you can make enough money to sustain your life, or as a result of a disability, you're prevented from doing that. Some of us parents do require our children to work. I'm just kidding, but the government does not. And so the definition is completely different here. It's really about the medical condition or the diagnosis that presents marked limitations. But for most of us, the question is adult disability, and that's why that definition is so critical. So how is SSI needs-based? Well, I kind of mentioned it already. There is a cap on assets. So in order to qualify for SSI, a single person cannot have more than $2,000 in the bank or in investments. All right. And if they're married, they get an extra 1,000, right? So it's 3,000. So at the end of the month, the government says, do you have more? If you do, you have too many assets, and we're going to discontinue your SSI until you spend below that amount. All right. So just a preview, Uncle Bob leaves me $20,000 because he's a really nice guy, and I'm disabled, and I have disabilities, and I can't work because of, a diagnosis. What has Uncle Bob just done? He's just made me have to spend 20 grand super fast in order to requalify for SSI. Now, believe me, Uncle Bob, thank you for the 20,000, but you can, with a gift like that, end up really creating more than $20,000 worth of problems for the person with disability. So we're going to talk about solutions to things like that as we go. Some resources are exempt. So fortunately, a house of any value is exempt. So that is interesting, right? I could have disabilities and live in a house that I own, but I can't have enough money in the bank to pay for the new roof, right, that I need on my house. It's just an interesting world. But having a house is fine. Having a car is fine. I did have a guy who came to see me who had disabilities, couldn't work, and he got in some kind of accident. He won a small judgment of $30,000, and he learned that a car is exempt. And so instead of, kind of figuring out how we could solve this problem, he's like, all right, I'm buying a Camaro. And that's what he did. And that solved his problem. He didn't have too many assets anymore. So that's how the system kind of works. That's on the asset side, but you also can't have too much income. And there are actually 4 categories of income. There's unearned income, and that's gifts. That's Uncle Bob giving me money. That's unearned income. Earned income is what you think it is. I go to work. It turns out that if I earn $1, I lose 50 cents of SSI. Okay. And the idea is if I can earn, $2,000 in a month, probably I'm engaging in substantial gainful activity. You and I may not totally think that's enough, but the way the law works is on the way to earning that, every dollar I earn reduces my SSI by 50 cents. So remember how I said you need $1 of SSI to get Medi-Cal? That's the key, right? So if I go to work for my mental health and also to contribute and do the things that I can do, I'm able to do, and if it feels good, I may not be able to work as much as I want to in order to keep the Medi-Cal. And so those of you who deal with this on a regular basis in your families know this well. Then there are the other 2 kinds. There's in-kind support and maintenance. And so that happens, let's say I'm able to move out. I have disabilities. I'm 30 years old, and I've developed to the point where, with some assistance, I can live in an apartment now. And that's great. Turns out that my $1,233 is going to help me with that rent. But let's say it's not enough. And so my parents decide, we're going to supplement Brian's rent, and they are going to pay the landlord an extra $2,000 or $1,500 a month. It turns out that payment reduces my SSI by $280 or so. It's a crazy rule, but remember how I said SSI was for food, shelter, and clothing? So the shelter portion of it is 1/3 of that, roughly. And when someone covers it for me, that's called in-kind support, and it takes away that 1/3. So there is a strategy that my parents could employ to keep me in the apartment and actually pay all of it without reducing my SSI. We'll talk about that later. And then there's deemed income. Now, deemed income is if I'm 16 and I'm in my parents' home, all of their income is deemed against my qualification for SSI, which is why you don't find very many young people young under 18 receiving SSI, because their parents' family income disqualifies them. Why? Well, because parents have a duty to take care of their minor children. And because of that duty, the government says, we're out. And that's what deemed income turns out to be. Yes, right. Yep. Now, that was the needs-based side. Remember, we also have on the financial benefits calculation, we also have Social Security and SSDI. It turns out that a disabled adult child of somebody who received Social Security, if they were disabled before age 22, and that's generally our population, and they're unmarried, and they have parents who've paid into the system and who are then retired, disabled, or deceased, an individual who meets those criteria can get disabled adult child benefits through their parents' work record, meaning that some Social Security money comes into their life. If you apply for it, it comes into their bank account. So what does that do? It's earned income, right? So every dollar of that Social Security disabled adult child benefit takes away a dollar of SSI. It supersedes the SSI. Fortunately, in this one case, the law says if you completely lose your SSI because you get this disabled adult child benefit through your parents' work record, we're going to let you keep your Medi-Cal. So there is a pickle. It's called the Pickle Amendment, and that's an exception in the law that allows for Medi-Cal to continue in that case. And then SSDI is for people with a work record. And it turns out if I go to work and then I'm out and I get disability insurance payments, every dollar of that is also earned income and reduces my SSI. So here's the thing. A young person could be getting SSI for many decades, and then their parents retire, and all of a sudden the SSI goes away, and they're getting payments from Social Security that they can't lose if they go to work full time. They just have to. I should restate that. They can't lose it because of work. They can still lose it because they're no longer federally disabled, because they can now engage in substantial gainful activity. But the bottom line is all these things swirl around together, and it is really critical for a lot of folks to get SSI in order to have Medi-Cal until their parents retire or pass away. And then maybe even after that, depending on how much the parents made during their lifetime. On the Medi-Cal side, or the medical side, remember, SSI leads to Medi-Cal automatically. There are other ways to get Medi-Cal. I'm sure you're familiar with Covered California. That is also a gateway or a way to get Medi-Cal. It's interesting. I think I had an asterisk and I forgot to take it out because that was when this was my prediction that there's no way that we're going to have no asset cap on Medi-Cal. And turns out that's right. We now have an asset cap again. But Medi-Cal provides medically necessary services, equipment, and hospitalization. It also leads to in-home support. In-home supportive services is a Medi-Cal program. And so the qualifications for Medi-Cal apply to that, even though it's administered on a county-by-county basis. And then I was giving this presentation once, and there's a lovely couple, and hand shot up, and husband said to me, "Have you ever heard of WPCS? Have you guys ever heard of WPCS?"
Yeah.
Yes. Okay. So it's rare. But here's the thing. How many of you have heard of in-home support? Right? Okay. What if it's not possible in a particular family for in-home support hours to fully cover somebody's in-home care? Right? It's 238 hours. That's it. What if somebody needs 24/7 care? Right? They need to be watched. Well, it turns out you can get a waiver of personal care services. You can Google it, and you can get a completely separate set of hours for your family. So if you have two people who are giving care in a family, let's say a mom and a dad, you can actually get more hours through that. And that can totally change a person's retirement calculation. It can absolutely change the quality of life for a family. And so when I heard that, I was like, wow, I learned something. So don't be afraid to raise your hand and tell me something I don't know, because it might make it into a presentation. But if you're in that situation, just remember that WPCS is an option, waiver of personal care services. Okay, to summarize, just to make it easy.
Right.
Yes.
Is WPCS different than supervisory, because I like
Yes.
SS, my daughter thinks she elopes,
Yes.
receives the additional supervisory, so we have 280 hours a month.
Right. Yes. It's additional. Yeah.
Okay.
That's additional. Yep.
Good to know.
Yep. SSI leads to Medi-Cal, SSDI leads to Medicare. Okay. So if that's all you take away, you're like, well, I know SSI is important, not only because it could turn into $1 million plus if we manage it right, if we can, but also because it leads to Medi-Cal, which is such a critical program. So what's at stake with special needs planning? Well, a variety of things. First, it's necessary to do this planning that we're going to be talking about this morning in order to empower the people that you want to be in a position to take care of the other important people in your life, right? The ones with disabilities. And so we've got to have this done in order to legally empower people. It's not enough just to say, hey, will you take over for me if something happens? That's great that the person's committed to that, but planning in advance is how you facilitate it. You can also protect what you leave to your loved one if you plan in advance from third parties, which is a way of saying, I mean, it's unlikely, but let's say I have disabilities and I'm walking through the parking lot and I'm not paying attention and somebody swerves and hits somebody, right? To avoid, tragedy happens. Well, what happens there? If I happen to have a lot of money from mom and dad, I could lose it in that accident. But it turns out if mom and dad leave it to me in a protected trust, like a special needs trust, that money is no longer available to a creditor or a divorcing spouse, a fortune hunter, or anyone else. It's creditor protected. You can protect against almost every creditor if you plan in advance, except the IRS and the Franchise Tax Board. Good luck with those guys. All right. And then the planning is the only way currently that a person can receive these critical benefits and an inheritance, both. It's the only way. People will call me and they'll say, hey, I read something on the internet. And I'm like, well, that's great, but that's not an option. This is the only way to do this planning. And what's at stake is, of course, peace of mind. So that's the fun category, category one. Now we're going to talk about making decisions for the future. And I'm going to give a little bit of an example here, a fictitious example, but maybe a familiar one. Anyway, Nathan, 18, lives with mom. Dad has passed away. He's diagnosed with autism. He has a part-time job, so he earns some income. He receives SSI because of his diagnosis, right? And Social Security because his father has passed away and he was disabled before age 22 and he's unmarried, right? So he gets some of that disabled adult child benefit. So every month he gets a payment from the federal government, and some of it is Social Security is SSI, and some of it is disabled adult child, and it adds up for him. He has a few personal assets, clothing, TV, knickknacks. Probably should have put PlayStation there, but that's what he's got, and he qualifies for Medi-Cal. Why? Because he gets SSI, exactly. So his mom is worried about all the things that you might imagine she's worried about. Who's going to make healthcare decisions? Who's going to manage his finances? Where's he going to live? How are his expenses going to be paid? And so she's got a bunch of options. She can do nothing, which is what a lot of people do. And when you do nothing, the government has a plan for you. And we're going to talk about that because it's not the best plan, but it is a plan. At least it's there. She could leave money directly to Nathan in a will or a trust. But of course, not every dollar, but when she leaves that money to Nathan, he's going to be over the asset cap and he's going to lose his SSI. She can disinherit Nathan. This is tragic. I can remember when I started doing special needs planning 20 years ago, I met with an older woman in a care home, and I had to shout for her to hear me. And it was quite a conversation. And she had disinherited her son with disabilities, and she could not get around the idea that she didn't have to do that. Right. But she gave it all to the other kids, and she said, I can't give him any. And that's not true, but she wasn't in a place in her life where she could receive the new information that I was giving her. So, and then she could also leave money to, say, her sister, who promises to care for Nathan. This is a strategy that a lot of us employ in the short term, but it's not the best, because what if her sister gets divorced? and all that money is in her bank account. Well, it's separate property, but what if she just wants to buy off her spouse and she's got access to this money? Or what if she gets in a car accident? Or what if she becomes incapacitated? Or what if she passes away and all the money goes to other people, right? There's so many things that could interfere. What if she just kind of loses it over time and just isn't the reliable person that Nathan's mom thought she was? Those things can happen. So that's not a great option. The best plan is, not surprisingly, to have a special needs trust. That's the solution to this problem. And we're going to talk about that as we go. We want to create an effective plan, and we're going to do it. Step one is to use what we call a third-party special needs trust. All right. What is a trust? Well, technically, a trust is a relationship that we have or that we establish in order to protect a beneficiary. It's a legal relationship. But the way I think about it is it's a bucket with instructions. Okay, that's how my brain works. And the idea is that I establish a bucket, I put my things in the bucket, the instructions apply, and they require what's in the bucket to be used the way the instructions say. It's enforced by law. It's a substitute for a will. It is an absolutely ironclad. When I die, those instructions are written in concrete at that point. When I'm alive, I can change them if I change my mind. But for the most part, they're absolutely set. The only person who can modify it in most circumstances is a judge. Okay, and they're not easy to convince to change someone's estate plan. So a trust is this bucket with instructions. The person who holds the trust is called the trustee. They're the person we trust to follow the instructions. If they don't, the law has penalties for them. It creates a fiduciary obligation. It's different than just, will you do this for my son? It's, you signed up for this, you agreed to do it, and here are the rules you must follow, or your pocket is potentially open to pay back what was done inappropriately. Okay, so it's a serious thing, the law says, to be a trustee. It's the bucket is held for the beneficiary, and the person who gets to, or the people who get to modify the instructions, we call those the trust makers or the settlers or the grantors. That's it. So there's three jobs: trustee, beneficiary, and trust maker. And when you're alive with the trust, generally you're in all three positions. So there's no one else to manage except your spouse if you're married or your partner. But what is a special needs trust then? It is a bucket with instructions that also happens to allow a person with disabilities to continue to receive their benefits, their SSI and Medi-Cal, no matter how much is in the bucket. If it's $100,000, great. If it's $100 million, well, that's even better for somebody, right? But what's in that trust is not counted against the $2,000 asset cap or the $130,000 asset cap. And when that money makes more money, it goes to the trust, and it doesn't show up as income, unearned or earned or otherwise, for the person. So it's the only way that a person can receive an inheritance and still qualify for all of the benefits that we have discussed. All right, so how do you establish a special needs trust? You establish it in your own plan, in your own trust. So a lot of people come to me and they're doing a plan for themselves to make sure that if they get too sick to manage things, their spouse or another loved one can take care of things for them. And then they're also worried that if they die, it'll go through a horrible court process called probate, and they don't want that. So a trust avoids that. So they do that. And then the question is, they have a loved one with disabilities. How is that person going to inherit? And in the instructions for their bucket, we build in the special needs trust so that when they die, that money, that bucket pours into the special needs trust. And that's all in one package. Other families will do it separately. They'll have the mom and dad trust, or the mom trust, the dad trust, grandma, grandpa trust, and they'll have a separate, completely independent special needs trust. And that is sometimes done because other people in the family want to give money to a trust for the loved one with disabilities. Because remember, if Bob gives it to me directly, I lose. But if he puts it in a special needs trust, he can do that all the time. Every year he could give $20,000. Uncle Bob, please do. Right. So that's how that would work. Now, we call it a third-party trust because, unfortunately, it all relates to the grammar rules we learned in junior high. And the idea is you put yourself in the shoes of the person with disabilities and you say, whose money is it now? If it's Bob's money, he's a third person. He's they, them, right? And him, her. So that's a third party's money. But if Uncle Bob dies and the money has come to me with disabilities already, we ask whose money is it? It's a first person's money. It's me, I, that's my money. So a third party trust is the kind we're talking about here. That's the kind you guys can do in advance in a way that protects everything. If Uncle Bob leaves me 20 grand and I already get it because he died and he didn't do this planning, it's first party money. And we're going to talk about the downsides to that. But there is a way, like I said, the government does have a plan. We talked about that. What are the trustee, the person who holds the bucket, what do they have to do? They don't have to be an expert. Like you don't have to have like a financial wizard as your trustee. I mean, great. If you've got someone in the family who can do that, fantastic. Maybe they're a good choice. But the trustee really needs to be the kind of person who's going to follow the rules. Now, they may not know them yet, but they'll learn them. You know, my office might share them. They'll have resources so that they can come up to speed, but they just have to be reliable and have integrity and be committed to the process. But they're going to have to invest and manage assets the way the law requires. They're going to actually have to spend some money. I had a woman come to see me and her sister had died and she was the trustee of a special needs trust for her nephew. And so far, so good. And she wanted some help. She wanted to learn what the rules are. And I told her that she was going to need to make distributions for the welfare of her niece. And she said to me, I'm not making any distributions. I said, really? She said, yeah, I'm going to save all this money in case there's a need someday. I'm like, well, that's okay. That's a good instinct. We want to protect. We don't want to just spend money. That's not the point of this. But you have a legal duty to use the assets in this trust for the benefit of your niece. You can't just sit on them. Now, of course, who's the contingent beneficiary of this trust when the niece dies? It's other family members, right? And so the law doesn't look at that and say, yeah, you should hold on to it because it might benefit your kids someday, right? You've got to use this money the way mom or dad intended it to be used. They've got to maintain records. If the Social Security Administration says, you know, what did you do with Nathan's money, right? How did you spend it? They're going to want to know. So records have to be kept. They have to file tax returns, and maybe for Nathan too. It's their duty to make sure Nathan's taxes from his his part-time job get covered. They've got to hire advocates. What if something happens in Nathan's life where he's not getting the treatment he needs? There's resources in the community here with UCP to help with that. There's the regional center. But what if something's gone sideways? The trustee is the one who's going to use some of that money to hire an advocate who can come in and push like a parent would for Nathan's benefit. Trustees' legal duties tend to be advocacy, accountability, and financial. Those are and I'll let you read that on your own time, but that's the kind of thing they need to do. They need to be an advocate. They need to be accountable for what they do, and they need to manage the money. So how do you manage it when you're not an investor yourself? You have a person at a company like Merrill Lynch that might have a history of investing for people with disabilities. There are financial advisors around that have specializations in our population. And so they're able to be what the law calls a reasonably prudent investor. They're able to make sure that the budget is set, that the goals are met, and that there's no more risk than needs to be taken, but also no less risk. Because Nathan, if he had a bunch of money in a trust, he's only 18. If that money was just put in the bank, well, it could spend it, but if it was just in the bank earning little tiny bits of interest, then by the time Nathan is a senior, his lifestyle is going to be dramatically reduced because of those early decisions made to be too cautious. On the other hand, if he's 90 years old, you wouldn't take risk with his money. You would have switched over time to a very cautious system because now we don't expect him to need, that money to double by the time he's 100, right? So That's how that works. Who should be trustee? Who should hold the bucket? Who should be the one to follow the instructions? Well, there's a lot of choices. You could have a non-professional family member do it. They're going to need professional help. They're going to need an attorney. They're going to need an accountant. They're going to probably need a financial advisor to do it right. But I tell you, we got a lot of qualified folks around who can help with that sort of thing. And so if it's your ambition to have your sister manage the trust, she could be the best person for that, right? But she might need some help, and she'll learn and she'll get good at it, and she can do a lot of the stuff herself as she learns. But there are resources for her. That's, I think, what most people in my experience choose is a family member. But there's also corporate trustees. These are not my favorite. We do have some corporate trustees around that are very thoughtful and kind, but you're dealing with an institution, and they tend to charge institutional rates, sometimes 1.5% per year of the trust. That's a lot of money to pay for that. It used to be people would say, well, I like it because there's no way the bank's going to die on me. But then I don't know if you remember Lehman Brothers, the bank that died, or Silicon Valley Bank died. So there's a sense that maybe that's not true. But we also in California have this great group of people who are called licensed professional fiduciaries. How many of you have ever met a licensed professional fiduciary? Anyone? Okay, so licensed fiduciaries are licensed. If you go to the Business and Professions Code, and why would you? But if you did and you opened it up, you could go to the chapter. This is my paralegal Terry here, and those of you online can't see Terry, but she's very nice, trust me. And she is licensed to provide paralegal services. If you flip to the next chapter, you're going to find the licensing scheme for professional fiduciaries. Okay, and they're licensed by the state as well to provide services as trustees for people who don't want or don't have family members who can do that work. Right? Some people don't want their family to have to take that on. I got plenty of cases where we'll have a professional trustee and the sibling of the loved one with disabilities is just there to monitor that trustee in the background, but they don't actually do heavy lifting in the trust. They just get to be a brother or a sister. And I often will just, even if mom and dad say, we have such a close family and Sally really wants to take care of Johnny and they're so close and I can't imagine that ever changing. So Sally will be the number one choice for trustee, but the backup, I'm going to try and talk them into vetting a professional just for their own peace of mind if they don't have another family member, so that if things don't work out, or there's, Sally has 5 kids and, is just really busy with her job and everything else that happens, she can still be involved and monitor that trustee. She still could have the power to remove and replace that trustee even with another professional if she needed to. So that's the way we often do it. And then the question is, what if your trustee gets sick, resigns, passes away, or just doesn't work out? There are solutions at a good trust that can be employed. So hopefully you're getting a sense that, or you will get a sense that one trust is not just like another. It's not like you go to the store and you're like, I need some soap. I could get Ivory, or I could get that, $20 really smelly soap that's on the display. I'm just going to get the Ivory, right? That's not quite what we're talking about here with estate planning. The more thoughtful you are, the better the trust fits the family, and the more peace of mind I think a person can have. And one of the tools that we have in our trust is a trust protector. That would be an independent party that a court could appoint to update your trust when you're gone for changes in the law. So how do you know your trust is going to work when you are gone? There can be tools put into your trust to make sure that it actually changes with the times. And a trust protector is one of the tools that we use for that purpose. What can a special needs trust buy? What can it buy? All right. So here's the thing. I think a special needs trust can do for your loved one with disabilities everything you can do for them. So if you're thinking, well, my loved one's moving into that apartment we talked about earlier, and I need to help with rent. And if I pay the landlord directly, I lose $280. My loved one loses the $280 of that SSI. I don't want that. There's a workaround. That same workaround the trust can use. Okay, we'll get to the workaround. It involves the ABLE account. But if the trust is drafted to be discretionary, that means it's a modern special needs trust, not an old one that allows the trustee to opt into or out of benefits programs as is in the best interest of the loved one. And they can figure out how to move the shells around a little bit. They can do everything you can do financially for your child, right? So, if your loved one's on disability or is receiving SSI, you don't just give them cash beyond $20 a month. The first 20, the government says, that's fine, you can give them $20 a month, but you're supposed to report any cash gifts over that amount. So what do you do instead? Well, if you have an ABLE account, we'll talk about, you put some money in there, and that won't count against the income restrictions, right? Or you could buy clothing directly, and then your loved one with SSI can spend their own money on the thing that they wanted to do, right? And so you can move it around so that your loved one has options, because money is fungible. It moves that way. So special needs trust really can do whatever you can do. Why don't you need one now? Because as strange as it sounds, you are special needs trust already for your kids. If they're over 18, what's in your bank account no longer disqualifies them from benefits. So you can do things for them the same way a special needs trust would. So you don't actually need a trust to replace yourself while you're alive. You kind of need a trust to replace yourself when you're not. That's the point. So step one is have that third-party special needs trust. That's the kind of trust that we're talking about. Step two is not a legal step at all. It's create a letter of intent. Has anyone in here done a letter of intent? Okay, I see some nods, but let me tell you about this. This is a great opportunity, and there's no reason why you have to wait to do this. But I recommend that every person who is caring for somebody in their family with disabilities do a letter of intent. This is where you lay out the medical needs of that individual, where you say what their likes and dislikes are, where you express your hopes and dreams for their care moving forward. It sounds daunting, but what I recommend is that you keep a diary by your bed for a month. And then at the end of every day, you kind of write down anything that occurred to you from that day that you would want to pass on to somebody caring for your loved one. Now, your loved one may advocate for themselves just fine, but there's probably still some things that you don't generally discuss with folks. This is where you put that in writing so that if something happens to you, there's a record and somebody else doesn't have to just figure that out, okay? So a letter of intent is critical. And in all of the special needs trusts that I draft, I put a clause in that says, if my client leaves a letter of intent, the trustee is required to consider it, required to read it, but not required to follow it. And the reason is remember, we want to give discretion to the trustee for maybe decades of care. We don't want to restrict them. So I don't want a letter of intent that says you must spend $1,000 a month on my child, right? Well, what if $1,000 a month turns out to be the equivalent of $10 a month, because of inflation? That's not the right strategy. The strategy is, I really want my loved one to be able to travel the way we do. And here are some of the things that I'm hoping you'll accomplish. I would like my loved one to have fresh, clean clothes on a regular basis. I want to make sure that my loved one lives in a house with assistance. But if that isn't possible, I've learned about this program that I think is a good option. Well, I'm going to put that information in this letter so the trustee has that information. Does that make sense? So doing a letter of intent is critical. I have a lot of clients who send me their letters of intent, and I just review them to make sure they don't unintentionally amend their trust in some bad way. And then we put it in the file. So what do you do moving forward? Establish a plan with a special needs trust, have a letter of intent, and then you've got to fund the trust. Remember how we talked about it being a bucket with instructions? You guys okay? Is this all right? I'm doing a lot of talking right now. Okay, good. All right. So it's a bucket with instructions. You got to fund it. So a lot of what that means is you got to put your stuff in it. So if you own a house, let's say, the title to that house, the title of my house is in my name and Jennifer, my wife's name, as trustee of the Wyatt Family Trust. That means it's in our trust. We still own it. It's in our names, but it's in our names in trust. That means that if something happens to me and something happens to Jennifer, our kids are going to have no probate and they're going to inherit the way the trust says with that house. Similarly, we've got bank accounts and investment accounts that are in the trust. My law practice is in my name as trustee of our trust. And there are special provisions in my trust for the practice if something happens to me, right? There's got to be a plan for that. So that fits your family and your assets. Some of you might have an IRA or a 401k or a 457 or whatever. That money has to be planned to come into the trust to take care of your loved one with disabilities, and it has to come in the right way. You just don't name the trust. The trust has to be drafted in a way to receive that money. So it all ties together. A good plan is not just I'll have a trust and I'll be done. It is I have a trust and I'm using it. I'm putting assets in it. It doesn't restrict your life. You know, if I go to sell my house, there's no extra steps. I just get a realtor. I market my house. It just turns out the seller is Brian and Jennifer Wyatt, trustees of the Wyatt Family Trust, rather than Brian and Jennifer Wyatt, a married couple, as community property. So it's the same deed, same process, no extra steps. But now my kids are protected. Now Jennifer's protected. Now I'm protected if I get too sick to manage things. And then the next question is, what about your loved one themselves? You know, can they execute legal documents? So I have a lot of folks who'll come to me and their loved one with disabilities is maybe, 17 and a half. And now they're like, well, wait, at 18, they're presumed to be an adult. And what do I do about that? And in many cases, if they're oriented in time and place, right, and I can explain something to them and they can understand it in at least a sufficient way, and they can say no to mom and dad, right? Then they're probably in a position to sign a power of attorney and a healthcare directive, and I've solved the problem inexpensively, very simply. But then I also have a lot of folks where those categories aren't met, right? If I explain something, they can't repeat back to me generally what it is, in their own terms, what's happening, right? It can be simple, like, if you sign this document, my friend, your mom and dad can go to the bank and they can spend your money, but they can also make sure it's safe. Is that okay? Is that what you want? Oh yeah, I want that. So what does this document do? I don't know. Okay, so that's a limitation where I would say I don't think it's ethical for me to have this person sign something, right? But if they come to me and they say that's what I want, and all they can say is mom goes to the bank for me, okay, we understand it. So most of my clients may not understand more than that when they sign their powers of attorney, so that's fine, right? So it's got to fit the family. But if your loved one can sign documents, then the things on this slide would be helpful for them to do. And if they cannot sign documents, now we're talking about a conservatorship potentially. A conservatorship is a guardianship of an adult. And when we're talking about the population that has developmental disabilities, we're talking about something called a limited conservatorship. I wish the name wasn't limited because it freaks parents out that they're going to have limited powers over their loved one. But the idea with a limited conservatorship is this is really for somebody with developmental disabilities. And the idea is many will adapt and grow and learn over, it might be slower, but they will still progress in life, hopefully, to the point where they need less assistance when they're older. And a limited conservatorship is designed to give back areas of responsibility to the person who was conserved if they right. Now, I have, to be candid, I think we have one case where that's happened, where parents have called me and said, you know what, we don't need this. We don't need to control where our loved one lives or the decisions they make in their relationships. The only thing we have left is the medical stuff because it's just a little bit more complicated. So we would like you to go to court and restore to our loved one these areas of that were given when they were younger. Okay, I've had that happen once, but that's the idea. That's the vision here, and it's a good vision that people with developmental disabilities can develop, and things can happen for them in many cases. And so let's make that available. So a limited conservatorship is really the kind that we get in most cases, unless there's a brain injury, then we can get a general conservatorship. I'm not going to go through all of this in detail now because it would just take a lot of time, but I think this does a pretty good job of describing the kinds of things that you need to know about a conservatorship. Maybe we'll do a conservatorship presentation sometime. Megan's nodding. If your loved one can't sign documents, a limited conservatorship over their person combined with a special needs trust that you've set up for them may mean that's all they need. They don't need court supervision over their money, right? So that is the best case scenario for a lot of the families that I'm working with. They have chosen a family member who will decide where their loved one lives, will protect them from unscrupulous parties that want to sign them up for credit cards all the time and have them buy, like I'm talking about my kids now, insane amounts of credits online, that sort of thing. So we can protect them medically. We can make sure that their education is covered through a limited conservatorship of the person, but their money is kept private in a private special needs trust that's managed by somebody else. That is a great combination for most people whose disabilities are significant enough that they need that kind of assistance. So if your loved one already has assets, Uncle Bob died and now there's $20,000. 20,000 is not a good example. Let's make it 200 because there are a lot of options for 200. For 20, it's a real problem. If you had $200,000, what can happen? Well, we can't do a third-party trust for Uncle Bob's money anymore. We have to go to court and establish a first-party special needs trust. Here's the bummer with that. Every dollar that's spent out of that trust is supervised by the court, and the court will second guess it. So this is what often happens if there's an accident or some sort of lawsuit that a person with disabilities wins, and a judgment comes in, that's their money. And so it needs to go into one of these kinds of trusts. And so I'll tell you, I have a client who had me go to court and establish, after a lawsuit, a special needs trust, first party, court established special needs trust for a young woman with Down syndrome who had won a lawsuit. And it was $300,000, right? So it's not nothing, it's something. And I'm, if you haven't noticed, a male. And the probate court asked me to explain to the judge in public why we needed certain more feminine things for this particular individual. And I was like, you're kidding me. But that's the level of scrutiny that the court will give. They can step in and say, well, I'm not sure that was the smartest thing to do, right? And then if they can call the trustee in, and where does the money come from to deal with that? It comes from the trust, right? When you have a third-party trust, you don't have any of that. It's all private. Yes, there's accountability that still happens, but it's private. This is kind of a bummer. But in return for that bummer, this young woman still has SSI and Medi-Cal. At the end of her life, everything in that trust goes to pay the government back for all the Medi-Cal she's received, all the in-home support, all of that she's received. So her loved ones will not see any of that money. But if we can spend it all during her lifetime, that's the ideal situation. It sounds funny. There's kind of perverse economic incentives there. I did have a case where it was another young woman who won a lawsuit. We established a trust. She had disabilities. We had a professional trustee, and it wasn't that much. It was $100,000, but it was enough to establish this trust. And we thought she'd be around for a long time, but she wasn't. She passed, unfortunately. And the way the rules work is that with that kind of trust, you cannot spend money out of the trust once the person has died on their memorial expenses. You have to prepay it. So you don't have any of these problems with a third-party trust. But now the family is like, they didn't have a lot of money. And you mean that we had saved this money thinking that this person was going to live into their 80s and it would be there for them when they needed it. And so we didn't spend it on anything now, and we can't even pay for the funeral out of it. Yeah. So some of these rules kind of stink, but that is what happens if you have somebody who doesn't plan in advance. And at least there's a plan that we can use. ABLE accounts. All right. How many of you are familiar with an ABLE account or have heard of that? Okay, good. So a lot of folks. In 2014, the Achieving a Better Life Act was Better Life Experience ABLE Act was passed by Congress, and of course it had to have a name. So ABLE is the name. It was modified in the tax cuts of 2018 and enhanced. And these are tax advantaged accounts for people with disabilities, and they're really cool if you can use them. They're not really appropriate in cases where the person with disabilities has no ability to manage the money long term. They're not really appropriate, in my opinion. But if they have a parent living, small amounts can still be good in that, even in those circumstances, put in an ABLE account for reasons that I'll get to. But let's say, you're unable to work because of a disability, but you are able to manage your debit card and go into the store or the movie theater and buy popcorn, or do some other things on that kind of level. ABLE account is brilliant because mom and dad can put money, or anyone can put up to $20,000 total in a year. That's the max into the ABLE account. And the person with disabilities can have that debit card and they can buy anything they want out of it. Now, are there some exemptions out there? Possibly, but the law says that basic living expenses are covered out of that account, and basic living expenses includes food and shelter. So this is the secret pathway for mom and dad if they want to pay a landlord and supplement a rent without sacrificing SSI, because it turns out you can have $100,000 total in a person's ABLE account before it impacts their SSI. So that $2,000 limit is now gone to $100,000. It also can be invested. Now, it's not great. You choose like 4 levels of risk, but it's something, right? So that money can grow. If you don't need SSI, but you have Medi-Cal, the limit is $435,000. Now, this does not substitute for a special needs trust because you can only put $20,000 a year in it. If the person who benefits from it is disabled, there is no way other than a conservatorship over that with all the court accountings to manage that money. So it's really just a tool that can be useful in some circumstances. But if my loved one's in that apartment and I want to supplement the rent, instead of writing the check directly to the landlord and losing the $280 of SSI, I put it in their ABLE account and I write a check. As the parent, I can manage their account. I write a check to the landlord out of that account. All I did was park it for a second in this account. And because of that, I call it legal money laundering. It washes the money and it can go to the landlord and there's no reduction in SSI. So it's pretty cool, right? Why is it this way? Because Congress put the ABLE account under the tax code instead of the Social Security code. And the IRS doesn't care about the Social Security Administration's budget. They don't care about all those rules. So they got to write the rules themselves. And so they wrote the rules so generously that allow a better life experience for people with disabilities consistent with the legislation. It's actually, you've heard of 529 accounts. That's because it's a code section. It's the Internal Revenue Code 520, section 529. These are 529A accounts. They're in the tax code, and that's why they operate this way. So in all of the trusts that we do, we put language in that allows the trustee to take trust money and put it in an ABLE account. And when we do that, we can launder money after mom and dad are gone sometimes, right? So that's the way. I feel like we're Breaking Bad here, and we're gonna have a car wash, but whatever. We're laundering that money anyway. There are a bunch of requirements and rules, and I'll let you read them. But I will say, a person has to be disabled before age 46. But Yahtzee, for most of us in this room, we know somebody who was disabled before age 46. So
Because it used to be 26.
It used to be 26, but as of January 1st this year, it's 46. Like I said, current as of now, but who knows what they'll do later, right? And this explains, these are, when you have a 529 account for education, you can spend it on education expenses. There's a list of things you can do, right? Education expenses do not include trips to Hawaii, right? But you could fund somebody's education and they have extra money left over and they could go to Hawaii on their own dime, right? So with a 529A account, we're looking for qualified disability expenses, which I have a huge list here. And fortunately, legal fees are even allowed out of this. So we can set up these to pay the lawyers. So that feels good to some of us in the room. But the idea is that basic living expenses is covered. And in California, that means food and shelter and clothing. So it's a pretty remarkable option. Choosing advisors. Okay, I'm not going to say a whole lot here. You've got the information in writing, but if you call your typical estate planner and you say, can you do a special needs trust? Many of them will say no, that's just not something we do. But there are a few out there who will say yes. They're small business owners and you're a potential business, so they're going to say yes, but they may not have the experience. They're going to pull something off the shelf and hopefully it works, right? But what I would say is it's good to have somebody who has experience. And I realize I'm kind of tooting my own horn a little bit, but there are a few of us in town who do a lot of special needs planning, and then there's the rest. And I would work with somebody, if you're like, that Brian guy, but find one of the other folks in town who really makes it part of their practice to do this so that you get the best of the latest and the greatest, and it fits your family, and they've thought about these things. It's not just a transaction. I don't sell documents in our practice. We make it really clear that we do planning and then documents, and then we help you understand what you've done before you sign it. Those are the things people pay us for so that it all flows for them. But planning is 45% of what people pay me for. It's not the documents themselves, right? And I think a lot of good lawyers, a lot of estate planners who don't do this work have that similar mindset. And that's a good planner for you and your family. If that's all you need is that estate planning, make sure you have somebody who doesn't look at it as, you're one of 1,000 people coming through my office and, we're running a factory here. Lawyers who are generally more oriented towards people and are, kind of seeing themselves as a family lawyer, as a place that you can go if you have questions. I have a lot of clients who will say, do you know anyone who can help with the unfortunate dispute I have with my neighbor over our fence line, and we can figure out somebody to refer them to. We don't charge for questions in my practice. I realize that other attorneys do, but when our clients call us, they don't get a bill. And that's intentional because I want them to call us. Maybe they'll remember who I am and they'll refer their friends and family, that sort of thing. But that's generally the idea, is we want our clients to come to us. Finally, procrastination. I mentioned that the law has a plan. It always does. And typically it involves a judge making the decisions. I have a friend who is an estate planner, and she told me once that she's got 2 sisters and she was trying to decide who would be the guardian of her kids. It's a little bit of a non sequitur, but it proves the point. And she's got these 2 sisters, and one is a corporate CEO, right? Buttoned down, really got her stuff together. The other sister is a bartender, right? Living her best life, no responsibility, tends bar during the day, beach at night, or beach in the afternoon, or surfing, whatever, you can imagine. And so she tells me this story, and she says, if I hadn't put something in writing and something happened to me, the judge would appoint my sister, who's the CEO. But I've seen her with her kids. I've seen her how she yells at her family. I don't like all the tension and stress. And my little sister, who tends bar, is the kind of person that I know would just get her act together and really provide a loving environment for my loved one. She may not have that financial acumen, but she could get help. And I know that. So when you let somebody else make the decision, they're going to decide what they think is right. And the judges will do that. They'll try to do the best thing, but they may not have the information that you have about your people. And so I always encourage people to keep that in mind not to let someone else decide. Estate taxes really aren't an issue for 99.99% of my clients because you can die with $15 million estate tax free now. That is constantly changing, by the way. But you can die with that amount tax free, and most of my clients are not over that amount or close to it, honestly. But estate taxes aren't an issue. It's probate that's the issue. If you have more than $208,000 worth of assets in California, you are at risk of a probate. A probate is this is what I came up with as a definition. It's as loaded as you can get. A lawsuit you file against yourself using your money for the benefit of your creditors, whether you have any or not.
Yep.
Right? That's what a probate is upon your passing. It takes 16 to 24 months on average. I've got one probate that's going 3 years now because they're a pain in the butt. That's the technical term. Thank you for that. And they're public. So what happens? We file a probate. Terry starts getting calls from realtors. I'm a probate expert. I'd like to sell that house that's going through probate. Well, how did you learn? It's public. They're watching the filings. I can go back and see how much people inherited through the probate court. And so it all in public. And then it's 5% of your estate, roughly, to go through a probate. So what that means is that if you have, let's say you have a home and it's worth, $600,000, and you have $400,000 of other assets and they all go through probate, that would be a $23,000 attorney's fee, a $23,000 executor fee, and $2,000 to $3,000 worth of court costs and publication costs. That's where you get up to 5% of that money. If you have a trust costs about a tenth of that, or less than a tenth of that. It's not $50,000. It's not $5,000 to do a trust. The most expensive is, maybe in some cases when we really have complexity, it could get up to that amount to do a special needs trust for a large estate. But generally, we're talking about $4,000 for a married couple and $3,000 for a single person to do a planning with a special needs trust built into it. And that is so much cheaper than this. This takes so much more out of the family than having that kind of planning. So you guys are here. You're not procrastinators, but if you know some, you might let them know. There are also people can fight, and people do when there's not a plan, and it's not in writing, and it's not clear. If it's ambiguous, if it was poorly written, there can be fighting. That's why it's good to have it done carefully. This is my last slide before the Q&A. I would say have a team, put it together. You don't have to have it all together right away, but over the next year, put it together. Have your attorney, talk to a professional trustee. We can give you some names. We can put that together. I would love it if you're in the room, if you could complete that yellow sheet and give it to Terry here. One of the things you can say on there is, please do not bother me or contact me. And so we will honor that. But if you need help or want to talk further, and I don't get to your questions, then feel free. Terry has a bunch of calendar spots open that we open in case anybody wants that. If you're online, I think Megan has sent this. Yeah, it's confidential. So there's our email for Terry on the top of the form. And you can also, if you're online, you can just email it directly to Terry. Preserve that confidentiality is fine. Even if we don't work together, it's confidential. That's the way it works. And then our contact information is there. So thank you very much. That was an hour and 25 minutes. Any questions?
I have a question.
Yes.
So back at the beginning, you said if they're on SSDI, so my son is he's almost 24. His father passed away, so he's collecting based on that adult stable child.
Yes.
Factor, right?
Yes.
So his grandfather passed away, and now he's set to inherit money.
Yes.
Which they want to put in a special needs trust. But if they didn't, you say that they couldn't take that money, right?
So the special needs trust is still valuable, right? It's valuable because the question is, if a person is receiving disabled adult child, they're not receiving SSI. And that's funny. I had a sip of water so I wouldn't get. Yeah, that was weird. So the question is, does receiving the inheritance now, does it disqualify from SSDI? No. So you could still have that. And you could, because you have SSDI, you have Medicare,
Yes.
right? And so all the medical stuff is covered, and Medi-Cal pays premiums if you have it for Medicare. So then the question is, let's say the person who's receiving the inheritance they can't work because of their disabilities, but they're basically capacitated, right? They can manage their life.
So he's also conserved, but
So he's also conserved. Well, let me start with my story first, then I'll get to the real story. My story is, if they're capacitated, then maybe if it's enough money, then they can pay the premiums out of the interest from the investments on their money, and they can control it. They just put it in a living trust. I've had this happen a few times last year. They put their inheritance in a living trust. They have mom or dad as their co-trustee to help them just manage around the edges, but they're not losing it. They're losing their Medi-Cal that pays the premiums for Medicare, but they can't lose Medicare. So they've got their medical covered. They just maybe need gap insurance, or the money from the investments in the trust is going to help them. And that, for some people, is great. Now, in the case where the person is conserved and is not going to be managing money, what do you do there? A special needs trust is ideal. They're over 18, so you'd want to do that because it's a system of management that protects. But yes, if they're inheriting less than $130,000, would I do it that way? I'd have to really look at that. If it was under the Medi-Cal cap,
it will likely be over.
okay. So then it's over. You could just conserve the estate, like you have conservatorship of the person. Conserving the estate means you can manage somebody's money.
Right.
You could hold on to it, and you could do it that way. Instead of a first party trust that pays the government back on their death, you would have to do a court established living trust out of the conservatorship. It's complicated, but you could swing it where you had all the protections of management with none of the payback potentially in that case. But the normal tool would be the special needs trust.
Right, and I think his trust was set up that way to funnel it into.
Oh, so it's a third party trust? Awesome. Yes. So yeah, then what that provides is asset protection, management, accountability, all of that. So it's not for benefits retention, but it is the kind of trust that is going to provide lots of other benefits.
Well, that was my concern, because that it was not going to affect his medical for sure.
Yeah.
Because he's going to have a transplant, kidney transplant soon. So I wanted to make sure that having that money in that trust was not going
It's not. It's perfect. Yeah. And so even if there's something that we're missing in some weird angle, he could have $1 billion in that trust that he inherited, provided it's a valid trust. Yeah, he's going to be fine.
Oh, good.
Yeah. I mean, now if the
That's
trust,
like
if the trust is misdrafted, I'm not commenting on that. It probably isn't. So you're probably good there. Yes.
So it's kind of a neat situation. I'm well, because I have my process. I'm disabled. My
Okay.
daughter's disabled.
Yes.
My dad's still alive, and he's always told us that he passes away, call so-and-so attorney. He's got everything set up.
Okay.
I've tried to convince him to funnel my daughters and mine into special needs trust, because
Yes.
if it doesn't, then I'm going to lose my benefits. She'll lose hers.
Right.
So what happens if he puts it into a regular trust and I have a special needs trust, but he's got it sitting over here in a regular trust? Is there any way to get that funneled into?
No, you can't. And any attempt to turn first party money into third party money is going to be unsuccessful and might inspire penalties even. So, no, but,
He's like, well, it's already trust, but trust typically, like, I never want to. Oh, when they hit 25, they get such and such amount. It's like, yeah, Dad, if it's over 2,000, she'll lose her benefit until all that money's gone.
So if he created a trust that's for life, so here's an exception. It's pretty narrow. But if so, when Jennifer and I pass away, our kids all are going to inherit in a trust. It's not a special needs trust. They each have a general needs trust. And the reason we're doing that is because it has the same protections against lawsuits and divorce that a special needs trust does.
Okay.
And I want that for my kids. It's like a once in a lifetime opportunity for them to be protected this way. They don't need benefits, but it's a lifelong trust. There is a rule, the Social Security Administration allows us to convert a lifelong inheritance trust into a special needs trust.
Okay.
But if it's the kind of trust that says at age 25, they get a third, at 30, they get
Then-
half,
Then you're in trouble.
and then you're in trouble because it's not for life. And the government's going to say, sorry, that's not the kind of trust we can let you convert. But there is the possibility. And what I would do is, in that case, we would go to court if it's a lifelong trust, and we would say to the judge, Dad just really didn't understand the rules. And although we tried to communicate, he was unable to receive that information. And because of changed circumstances, we now go in and modify the trust. So you can do that, but not in the case where it's the staggered inheritance.
And that's important. I don't know what the trust says because
So here's the thing: if it comes right to you, and it's a substantial amount of money, you can still protect it for your child, right? You can do your own planning. You just might lose some of your own.
I'll lose my SSDI.
Not SSDI.
My medical.
You'll have, if you have SSDI, you'll have Medicare still, and you'll have SSDI, but you'll lose your
Benefit amount. Depending on.
Yeah, depending. Yeah. I think you might be okay as long as you do the planning after the inheritance for your dog. Okay. Next. Yes.
This is about label a good tool for the beneficiary count financial supplement.
Yes. So the idea is the ABLE account rules are that a parent, so the person with disabilities, their parent, their legal guardian or conservator, same difference, can manage an ABLE account. If the person with disabilities cannot manage it, while their parents are alive, parents are fine to manage it. But once the parents are gone, now you need a court supervised management of that account. Right? You need a conservatorship of the estate to manage it. And that's why what I'm saying is the ABLE account itself doesn't get you anything a special needs trust doesn't get you. You might as well just use a special needs trust instead of the ABLE account in that circumstance. The other thing is there are no beneficiaries on an ABLE account. At least that's what I currently understand. So correct me if I'm wrong, but I don't think you can add any beneficiaries. So when a person with an ABLE account dies, if it's over $208,000 in the account, it goes through probate. And during the probate, the Department of Healthcare Services becomes a creditor and takes that money. So it's a payback, right? So the ABLE account in the situation where a person cannot manage it is fine for small amounts that you kind of move right through to do something like pay that landlord, or just have basic spending money for the loved one with disabilities so that they can have that money. You put $100 in at the beginning of the month and it's gone by the end. But if it adds up to more than $2,000, we're not really worried about it. But we don't want a lot of money in there, because if it's a lot of money, then you're going to have court supervision. Why don't we want that? Because it's $3,000 to $5,000 every 2 years to go to court to present the accounting to the judge out of that money. That's a waste of money. It's unnecessary hassle. And the judge will scrutinize all the expenditures out of the ABLE account. So you don't have any of that with a special needs trust. So an ABLE account is not a substitute for a special needs trust. It's only a tool that's really good for people who can really maximize it, or for little side projects. Does that make sense?
I still don't quite understand. I'm thinking of what you said, that let's assume that we have a special needs trust, and you said that having a CalAble account would be a good way of laundering or cleansing the certain certain expenditures. So it's good to have
Well, you're alive.
two of them.
Well, your mom and dad are alive. But once mom and dad are, it's not really a good tool for that anymore. Because the only way it can be managed is by the person with disabilities themselves. And if he or she can't do it, then it has to be court supervised. And now if it's under 15,000, you can get an exemption. But it's still going to cost you, $5,000 to go into court to get control over an account that has $15,000 in it. See what I'm saying? It's like an inefficient use of money, whereas the special needs trust you've got can have all of the money in it with no problem, because you've got a system already in the instructions for the bucket that tell you how it's managed and who's the backup, and it's all. And if there's vacancies, how do they get filled? And all of that's in the trust. You don't get any of that with an ABLE account. An ABLE account is just a tool for certain circumstances. So we want it in the toolbox, but we may not use it after you're gone. Sure.
Yeah, we've got a bunch of questions online. I'm going to go in the order that they were received. So if you have a special needs trust for your child/adult, when you fill out applications forms and they ask about bank accounts, etc., do you list the trust or do you leave that off?
Oh, good question. So you're talking probably about Social Security. And so it depends. That's the lawyer answer. It depends, because if you say you have a special needs trust, what do you mean by that? If you mean that you have an estate plan, and in that estate plan, in the instructions for your bucket, it provides that when you die, there will be a special needs trust. You don't really have a special needs trust yet, right? If your friend said, did you do a special needs trust for your child? You'd say, yes, of course we did. But if the government asks you, do you have a special needs trust? You would say no, because it's built into the instructions, and you haven't. The triggering event is your death, and you haven't died yet. So that I'm not dead yet. So I don't have the trust yet. If you tell the government that you have a trust that you don't have, they will never be able to unhear that information. So what'll happen is you will say to them, I'm so sorry, I misspoke. I really don't have a special needs trust. And they'll look at you and say, I totally understand that. Can we have a copy of the special needs trust? That's how the conversation goes. And so to friends, you say, we did the planning. But to the government, you don't say that. But let's say, in this case, you're talking about the scenario where you have two trusts. You have the family trust, and then you did that trust that Uncle Bob could give to if he wanted to. You did a standalone special needs trust. By the way, 95% of our clients just do it built in. They don't do the two trust model, but some do. There's really reasons to do it. And when they are, your attorney should do it that way. So let's say you have an actual special needs trust. Do you have to report that to the government? Yes, you do. In fact, you have until, I think it's the 10th day of the calendar month after you first put money in that trust to give a copy of the trust to the Social Security Administration if you're receiving your loved one's receiving SSI. And you better send it certified mail, because as soon as it arrives, there is a 50% chance they'll lose it. So you want it certified mail with the return receipt, so that later when they discover, oh, you didn't tell us you had a special needs trust, you can say, here is signed by the front desk person at the local Social Security office, right? And so that's part of it. I'm sorry, this is a long question, isn't it? So you have that, and then the question is, what do you disclose on the form? I do not fill out those forms. No one wants to pay my hourly rate for me to do that. So I'm not going to speculate on that, but I would say you should disclose any accounts that are in the name of your child, and you must disclose the existence of the special needs trust. And when we send the letters to the Social Security Administration disclosing the trust, we generally say it was funded with X dollars on such and such a date, because you can't have a trust in California without something in it. You have a bucket with instructions, but you actually have to put at least $10 or something in it. So we have to tell the Social Security Administration. If you really need help on benefits, qualifying and managing the Social Security Administration, I have a guy whose number I can give you, and he does this for a living. He helps parents and banks and families figure out like, how do we manage the benefits? But no one wants to, they'll pay his hourly rate, but not mine for that. So sorry, I'm going to have to pass on that. Next.
Okay, next question. We already have a revocable living trust. Can it be amended to include a properly drafted third-party special needs trust for our disabled son so that his SSI Medi-Cal will not be affected? Or do we need a completely separate special needs trust document?
No, yes, the answer is brilliant. The question is brilliant. The question is, do I need to start over if I've already done my living trust? The answer is no. It just needs to be restated. So we keep the same name and date of your original trust, and we just change the instructions. So you don't have to go back to the bank and retitle your accounts in the bucket. You don't have to redo your house title. You come in, we do the planning, we update it all so it flows from beginning to end. It's a start over project for me, but for the client, it's super easy because they have done most of the work already. It's just, so if, one of my kids, Ben, develops disabilities and we have to do a special needs trust, the Wyatt family trust would just be amended by Jennifer and me, and we would include the language for Ben's special needs trust in that document. And so that's how we would handle it. So yeah, good question. It's easy to change your living trust.
Okay, the next question is from Natalie. So as parents, we need our own trust for the family. Do we exclude the name of our special needs daughter in that trust? And then we need to set up a special needs trust just for our daughter. Daughter is 15 years old now. Do we have to wait until she's 18 to set up a special needs trust for her?
No. I would say you decide when you start. And it has no trigger in terms of the age of your daughter. You have your own living trust, the bucket with instructions. Those instructions specifically say when you die, a share of that trust, or all of it, depending on how many kids you have that you want to give money to, pours into a new special needs trust that comes into existence on your death. It's all built in. So you don't have a separate trust. If you did a separate trust because you have an Uncle Bob who wants to give to your loved one, and you can't convince Uncle Bob just to give it to you, so you can give it to your child, which is the better way of going for a lot of cases, especially if it's 20 grand, then you do a special standalone trust, because we don't know when Uncle Bob's going to die, and we need the trust, on his death. But if you can build it all in, we would just update your living trust. You'd have one document with everything built in. Yep.
Okay, next question. As parents contributing to the ABLE account, is there a tax write-off for the parent?
Oh, good question. So the tax advantages. So first of all, if I give $20,000 to somebody, it's gift tax free. If I give $20,001 to somebody, I've got to file a gift tax return to tell the government that I made a gift over the $20,000 limit, and there's a $1 excess. But I mentioned that a person can die with $15 million estate tax free. You can also give away $15 million during your life estate and gift tax free. So that just means that I have $14,999,999 left of my tax exemption when I do that. But so the idea of funding an ABLE account, the maximum you can put in from any source is $20,000 in a year. So if I have a loved one with an ABLE account and I give $20,000 to that account, nobody else can give any more, because that would boost it over, right? But for me, I have no gift taxes because it's the $20,000 limit. I haven't gone over that. And this year I funded their ABLE account. That was my gift to them for the year. So there's no gift tax. Is there a deduction? No, because that's post-tax, or that's taxable income that I got and I put in there. Or maybe I went to the bank and I already paid taxes on it, and it's bank money that I just put in there. So it doesn't protect against income tax, but that money grows in the ABLE account because it's invested, and then it's spent on qualified disability expenses, including basic living expenses. There is no taxation on that money. It's tax advantage. Just like if I spend out of a 529 on my kid's college, if it's on the education expenses, all of that growth in that account is tax free because I've done what the government wanted me to do with that account. So it's the same deal. the growth is tax-free in the account, but whether I pay taxes before I put it in there depends on how I got it. Was it work? Was it a gift from somebody, or whatever? So there you go. Hopefully that answered that.
Okay.
What else?
Next question. When is the best time to put the special needs trust together? Specifically, if you expect that your financials will change in the future. Let's say you are planning to purchase another property.
I would do it now. And here's why. It's a bucket with instructions. The instructions don't have to refer to specific properties. They can, but most of my clients will say, let's just take my scenario. I got 3 kids. So Jennifer, if I die, Jennifer gets all of our wealth. It goes to her. It stays in the trust for her benefit, right? When she passes away, it splits up into 3 shares. Our kids get a third each. At least right now they do. But there are a couple of them that I'm kidding. But they get a third each, right? And so if we're down to our last $1,000, then they will share $333. If we have 4 homes in the trust, which we don't, but if we did, then all of those homes could be sold and they would each get a third, or they could mix and match assets at that time. But the rule is you have to get a third. Now, if I had instead had 4 homes and I said, Ben gets the one on Main Street and Sophie gets the one on, South Street, and Lily gets the one on North Street, those, and then I changed I sold the house, then I would need to amend the trust. But most people don't do it that way. Most people do it in percentages or shares or dollar amounts. And so it's not like my clients are coming to me and constantly amending their trust. They're doing it when something significant changes. So I would say to that person, they should do their planning, get the benefit of the peace of mind. And so when they buy that new property, it can be titled correctly in their trust, and they don't have to do an additional step after they buy that property and calling their lawyer to have it put in the trust. So that's doing it now makes sense. Unless, of course, it's not the right time in your family to do it.
Okay. Next question comes from Margaret. Are property taxes and homeowners insurance considered housing? Leaving home to special needs adult child, thinking about having monthly survivor benefits from my employment to fund these taxes / insurance.
So yes, it is possible that some expenses can be considered payments for shelter, and reduce potentially the 200, the 1/3 share of the SSI amount. That's really what we're worried about. But it's a shell game. So if there are other expenses that can be paid to free up money from the SSI check to pay, some of those shelter expenses, then there's no reduction, right? In other words, a person receiving SSI can pay their own shelter out of the SSI without any problems. The question is, if someone else pays the shelter expenses, does that reduce their SSI? And so if instead the trust pays their phone bill and their pays a bunch of other stuff, then maybe their SSI money is free to the extent that it can cover utilities and it can cover other expenses that would otherwise be shelter. The other possibility is it's just a scenario where you're going to lose $280 of the SSI money, but you're going to have everything covered, and that's okay, right? You just do the best you can. My friend Jim Hike, the benefits consultant, would be the better person to talk to, though, about structuring that kind of thing. We're really good at doing trusts and conservatorships and getting them done right. But like I said, no one really wants to pay me my hourly rate to advise them on SSI. So there you go.
Okay, next question from Beth. Options if married but separated, not legally from spouse. They are unwilling to participate. What are my options for estate planning special needs trust? Question mark.
Yeah. What?
Given from my circumstance, trying to get public assistance in that situation, they wouldn't help out until I filed in court.
Yeah.
So it may have to follow.
Yeah.
The same.
I mean, the thing is, people have, when you're married and you are not legally separated, and you haven't announced that you're planning to end the marriage, you still have community property. And every dollar that you have earned and every dollar that they earn are community dollars. And you're a fiduciary to them and they're a fiduciary to you. And I don't want to say the words out loud that I'm thinking about that because I don't like those words. But I don't have a good solution to that. Sorry.
Okay, next question. Son receives disabled adult child benefits due to dad's retirement.
Okay.
Did you state that a person with these benefits won't lose their benefits from working? Also, what is the limit for Cal-Able with disabled adult child benefits?
Okay, so disabled adult child benefits are an entitlement and cannot be lost. But if you go to work, you may no longer be federally disabled. Depends on if you engage in substantial gainful activity. So what's the limit there? Earlier in the talk, I talked about $2,000. I think you're at risk once you hit technically about $1,000 of income. I think that's where I can't tell you for sure. My friend Jim would be better on that, but my understanding is that if you make more than $1,000 a month, you may lose the status of being disabled because you're engaging in substantial gainful activity. And then in that case, you would no longer be disabled and therefore no longer entitled to disabled adult child benefits. The difference, though, is back to Uncle Bob, and I do have an Uncle Bob. Do anyone else have an Uncle Bob? Okay, we got like everyone in the room has an Uncle Bob. So that's good. It was a good guess. So Uncle Bob, gives $20,000 to your son while he's receiving, or your child will, they're receiving disabled adult child benefits. That money is not a problem because that is not substantial gainful activity. That's just money coming in, right? And the key is, are you disabled? And someone giving you money doesn't undisable you.
It doesn't make you not disabled.
Thank you. Doesn't make you not disabled. So that's that's the key. It's really the question of substantial gainful activity.
Okay, next question. Can trustee fiduciary services be put on the self-determination program spending plan through Alta?
Don't know. Ask Alta. Yeah. Normally, trustee fiduciary expenses are paid out of the trust. That's where they go. So, I have had a special needs trust with $100,000 in it with a professional trustee. Now, I think I already mentioned that. Does that do a whole lot regularly? No, but it's there as kind of an emergency supplemental fund, and it works fine. But if you had $200,000, now you've got $15,000 maybe in interest income and maybe a couple $1,000s worth of expenses. You've just supplemented your loved one by $1,000 a month in extra care, probably. So I'm not saying that that's like the limit or anything. Anything you give to your loved one or anything you leave is a blessing if it's left the right way to them. But if it was a $20,000 amount, we wouldn't set up a special needs trust for that. I mean, we could, but it would have to be a family member managing it, and it would have to be, So anyway, one more here. Yeah.
So with a special needs trust, it can be, so you fund it, but what if, like, you have more than one person that ends up putting money, like my dad and then my stepmom or whoever?
Yeah.
They can receive money more.
Absolutely. If it's third-party money. What you can't do is have a special needs trust, a third-party special needs trust, and then take the monthly Social Security money that comes in, the SSI money that comes in. That money can't be put in the third-party trust. That's commingling and messes it all up. So it would have to go in a Cal-Able account, yeah, or it would be spent, or it could go in a first-party trust, theoretically.
Okay, next question from Shadia. What do we do if we want to trust for both our special needs adult child and our other non-special needs adult children?
Yeah, you do kind of what Jennifer and I did. You develop a plan. we can put it together so that you have a living trust, and then when you pass away, it splits up into shares. And the share for loved ones with disabilities is in a special needs trust, and the shares for those who are not having disabilities or not disabled, they will be held in. They could go outright and just be gifts, or you could do what Jennifer and I did, and we could have trust for each of them and protect them from lawsuits and divorce. They can be their own trustees. So a general needs trust beneficiary can be their own trustee and still get all the protections. But you can't be the trustee of your own special needs trust, because now you have control of the money, and the government says, well, sorry, we're not going to give you, if you're in control, you're in control. Right? So.
Okay, next question. As the laws change, are law firms required to notify their clients of these changes so that client can update their trust? And does every update based on changes in the law cost money?
First question, no. Second question, yes. Yeah. Yep. Yeah. So, but how often does that happen? So 2003, 2004, we had the HIPAA laws passed. HIPAA is the medical privacy law. And if you were reading the Wall Street Journal, if you were subscribed and you read all the way to the back, you would have found an article at some point during 2003 that said privacy laws mean you have to update your living trust, right? And they do, because most trusts say that the standard for someone taking over to manage your affairs is two doctors saying in writing that you can't manage your affairs due to age or injury or illness. It turns out that's medical information, and doctors can't write those letters unless there's a release. So if you have a trust that was done before 2003, 2004, you automatically are at somewhat of a disadvantage if you haven't had it updated, right? So is it required that attorneys go find their clients and tell them? No, it isn't at all. Is it to the advantage of the attorney to do that? Absolutely. It is to the advantage of the attorney, because the answer to your second question is, does the attorney get paid when they work? Yeah, they do. So if you want to make a change based on family changes or legal, changes to the law, then you call your attorney, and if you end up doing that, they charge you for the work that they did in that regard. But how many times does that happen? How many times has there been a significant change like that? For most of my clients, the answer is it hasn't. There have been little changes and tweaks and things that that could justify changes, but don't require any changes. So in those cases, it's a balance, right? Is that I know a lawyer in town that sends a letter to their clients every year that basically impresses on their clients the need to come in that year and get changes to their trust. I disagree with that way of practicing, because I don't think that's true, right? On the other hand, if you have a trust, maybe every 5 to 10 years, it's good to have an appointment with your lawyer to go over it and make sure that nothing has changed, right? Or even just a call to the office. It's a two-way street. It's really a relationship that's necessary. So we do reach out to our clients when there's something obvious, but there really hasn't been something like that privacy law that was passed. The tax laws have changed. Some of my wealthier clients, there's different circumstances for them, but in general, no.
Okay, we have two more questions. Question about life insurance. Does that get put into a special needs trust?
It sure should. Yes. It's also taxable. So I kind of mentioned it on one of the slides. Right now you can die with $15 million of state tax free. That includes your life insurance in most cases. Most of us don't have $15 million worth of life insurance, but just know that that $15 million number is in law now. I think it's only there for 10 more years. And then it rolls back to where it was in the Obama years. So it might be 6, 7.5. But I can name 4 or 5 presidential candidates who wanted that number to be 3.5 million. And the tax rate's 65%. So the idea is, okay, now if it's 3.5, there was a time when Jennifer and I had enough life insurance because of the 3 kids to potentially get us into a taxable estate where we would have to spend, some money on that just on the basis of life insurance. So that's way more complex than most of us need to care about today. But if you're in that place where you're like, yeah, I might die with my wife and I, or our family might have more than 3 million, you know, it's a real issue to think about estate taxes in that case.
Okay, final question. Do you have recommendations on fiduciaries?
I do, yes. I'm not going to put them on recorded, but if you come and see me, and I'm happy to give you our list. We have some. It's not that I'm afraid to give them, but the reality is, I want it to fit your circumstances, and I want to be able to talk to you about some of the best fiduciaries have the worst online reputations, and that's counterintuitive, but just as a kind of a preview of the conversation I would have with you, some of my favorite fiduciaries in town are the ones that take the hard cases. So they take cases where there's family conflict, where someone's going to go online and make accusations, or whether a beneficiary has a mental illness that makes them detached from reality, and part of their symptoms are thinking their fiduciary is stealing from them. Not true, but it's all over the internet, right? So some of the best people and the most responsible people are the ones that get attacked the most. And so I like to have those conversations in person. So thank you very much. We're actually at 12 o'clock, so we've come to the point. Yeah.
Thank you. Thank you for guys for staying online with us. We will send out the recording to you guys just so you can have it if you want to share it with your partners or anybody else close in your family. And again, you have all of Brian's contact information, and Terry is here if you want to come and schedule an appointment or do any of that. She's here to help that. So thank you. And then Cameron and I will be sending out a post-event survey. Part of that, we just want some feedback so we can know what to do better, but also Brian mentioned potentially hosting a conservatorship seminar. So we're looking at what kind of programs you want to hear so that we can put more information together for you and host more of these events for you.
Yeah, that sounds great. Thanks, Megan.
Awesome. Thank you, everybody. Please grab coffee and treats on your way out.
And don't forget the yellow sheets if you're here.
Yes, yellow sheets. We'll take them over here. Oh,
Yeah.
please just be careful with this.
And inform, right?
Yes.